Morning, everyone. Thank you for joining us for the first GC Know-how session of the year. Is a share buyback right for your company? Today's presenter is Georgia Haller, a managing associate in our corporate team. Georgia has experience advising clients on a range of UK and cross-border corporate transactions, including mergers and acquisitions, private equity-related transactions, joint ventures, group reorganizations, shareholder disputes, real estate finance, and general corporate advisory work. So I will hand over to Georgia to begin. Thank you.
Thanks, Shireen. Morning, all. So as introduced, we're going to do a session on share buybacks, and we'll try to make it sort of practical and commercial as possible and not bog you down too much in all the legal requirements, because often deciding whether it's right depends on your circumstances. So we'll have a look at where it may be appropriate or where you may be considering other routes instead. So quite a lot to get through. So it will be a little bit of a whistle-stop tour. But if people have questions as we're going through, please jump in as we're going. That's not a problem. So we'll, as you might expect, look at the main reasons that companies consider a share buyback. We'll have a quick look at buybacks versus dividends versus capital reductions, because in some circumstances, a company may be considering one or more of these and which one's the most appropriate for their particular circumstances. Then assuming that a buyback is decided as the most relevant route for a company, looking at the key considerations to take into account when carrying out a buyback to make sure it's validly executed. The methods of financing a share buyback, generally speaking, there's 4 different ways of carrying out a buyback, and they're all to do with how you finance it. And then linked to all of that, the circumstances that can mean a buyback is void. So the common pitfalls and mistakes that are made and possible rectification actions if it does look like your buyback was void. So given our common client base, we're focusing in this session on buybacks for private limited companies rather than public companies. But please get in touch afterwards if it's helpful to discuss the latter. So why might you undertake a buyback? The nicest reason for wanting to do it is that the company's sitting on surplus cash. So perhaps it's had a particularly profitable period, or it's recently raised finance for a particular purpose that's then fallen through, or it's sold material assets or a subsidiary perhaps. So it's sitting on a bit of extra cash. It's often not efficient for a company to sit on too much cash that it doesn't have an identified purpose for, and shareholders will often want that cash returned to them. So in that scenario, a buyback can be a useful tool. The obvious other option available would be a special dividend payment. And we'll come on in a second to look at the differences between the two to help decide which might be better for your company and your shareholders. The most common scenario where we see a buyback, though, is to facilitate the exit of a shareholder. So it doesn't have to be contentious, but often a shareholder is exiting. Maybe there's been a fallout and you want to buy back the shares from them, or they're kind of everybody's friendly and they want to leave for whatever reason, but you don't want them to retain the shares, so you may want to buy them back from them. That's the most common route. It's the one we see the most often, particularly for younger companies that maybe aren't ticking the extra cash box. You can also see them where an employee shareholder has exercised options under a share option scheme and has been issued shares, and then that employee leaves the business. So you might want to buy them back in that scenario. Something that comes up less often but is worth thinking about is a scenario where one of your shareholders, particularly say a founder shareholder that was quite key to the business, has passed away. Ordinarily, their shares would then pass into their estate and can be registered in the name of the personal representatives or executors. And it may be that you don't want them to hold the shares, or it's sensible to amend your articles to include specific provisions where you can buy back the shares from a deceased shareholder. It obviously depends on the particular circumstances and what you have agreed with that shareholder in the event of death and treatment for their estate, but it can be a useful tool to have in your articles, but needs to be specifically added in. So it's worth thinking about whether amending articles for that would be useful. And less relevant for private companies, typically seen for public companies, but may still be relevant depending on investor requirements or third-party financing requirements. You might want to carry out a buyback in order to cancel shares to increase your gearing ratio, so your ratio of debt versus equity, or your earnings per share, where both of those ratios go up if the number of shares goes down. So that may be relevant to private companies, but it is more typically seen for public companies. Or it may be that you have done some kind of reorganization, where as a result of a consolidation of shares, you might have ended up with some fractions of shares, or perhaps a shareholder's shares have converted into sort of a worthless class of shares, such as deferred shares, where they don't have economic rights, they don't have voting rights, and then you want to tidy that up and effectively buy them back and cancel them and remove that kind of class of share. So there's a lot of different scenarios where it may be a useful tool, but as I say, the most common one is often on the exit of a shareholder. The type of buyback that will be most appropriate to you will be no surprise. It depends on the circumstances and the purpose of the buyback, which we'll come on to a bit more. So just briefly looking at whether a buyback or a dividend or a capital reduction is most appropriate. The deciding factor here is twofold, primarily the purpose of what you're trying to do. So is it that you're trying to return cash to the shareholders? If so, you're most likely looking at buyback or dividend. Or is it that you're trying to take back the shares so that you can cancel them, in which case you're looking at buyback versus capital reduction? And then in those two scenarios, your deciding factors are most likely going to be determined by whether the company has distributable profits. If it does, then sort of all of the options are available, but if it doesn't, then a capital reduction is probably the most useful, or you need to do a capital reduction first to create sufficient distributable profits and then carry out your buyback or dividend. And another key consideration, possibly the most key consideration, depending on your circumstances, is the tax implications. So the key things to be aware of is that a dividend, as I'm sure most people are aware, will be treated as income and therefore subject to income tax treatment. But in certain circumstances, if certain conditions are met, then a buyback or a capital reduction may be treated as a capital gain and subject to CGT treatment, which then is a lower tax rate. So that can be beneficial. It should also be remembered that on a buyback, if the purchase price for the shares being bought back is £1,000 or more, then the company will be liable to pay stamp duty at 0.5% on the purchase price. So it may be that it's beneficial to the outgoing shareholder to do a buyback, but the company should be aware it may be liable to stamp duty. So it all needs to be considered in the round. And as with all of these things, obviously speaking to lawyers is a good idea, but also your accountants and your tax advisors to determine the best route available. In a second, I've got a table that kind of sets these out in a bit more of a helpful format, but a couple of other things to think about are whether the shares that are relevant in this scenario are fully paid up. You can only buy back shares or pay dividends on shares that are fully paid up. But for a capital reduction, the shares can be partly paid or even not paid up at all. So that may help. Obviously, a way around that is paying up the shares first, and then all the options are available. Depends if there's going to be a concern over shareholder consent for these routes and what majority of shareholder consent you can achieve. So generally speaking, a buyback only requires an ordinary resolution unless the articles state that a higher threshold is required. So it may say that this is a particularly important issue and they increase the threshold, but the default position is that only an ordinary resolution, so 50% or more of the voting shares voting in favour, whereas a capital reduction requires a special resolution, so at least 75%. And for a capital reduction, you also need a solvency statement. So if there's any concern about whether the company is solvent and whether it's going to remain as a going concern in the next 12 months, then it may be a buyback is more appropriate. But again, it all depends on the specific circumstances of your company at the time. So this might be a little bit more useful, just running through some of those points to compare and contrast. So thinking about whether your shares are fully paid up, not relevant for capital reduction, is relevant for the other options. Do you have sufficient distributable profits? Not relevant for capital reduction, and that's often used to create them. It is relevant, most likely, for the other scenarios. What's your tax treatment? Are you trying to cancel the shares at the end of the process? Obviously, it's not relevant for a dividend, but you can do this and should do this for a buyback or a capital reduction. Solvency statements only relevant for capital reduction. Is there a desire or flip side concern about potentially increasing the percentage shareholding of your remaining shareholders after you've carried out one of these events? If you want to kind of everybody benefit in an uplift, then a buyback is useful if you bought back the shares and then cancelled them, because everybody else goes up because you've taken some shares out of the pool. It's obviously not relevant to a dividend, and a capital reduction, generally a price pro rata. Everybody would be prorated up. So it depends whether that's a benefit or not. Again, the type of resolution that would be required. And one of the key differences is payment of the purchase price in each of these scenarios. So for a share buyback, the purchase price must be paid in full, in cash, on completion of the buyback. It can't be deferred or paid in installments or contingent and paid back in the future. That would make it void. So sometimes companies don't realise that they have to pay the full purchase price up front. So it can't really be subject to an earn-out or paid in tranches. But in a scenario where you're paying a dividend or carrying out a capital reduction, it is possible for the amount due to the shareholders to be left outstanding. So again, the financial position of the company needs to be taken into account. So say you've kind of weighed up your scenarios and a buyback is the most appropriate or only option available to you. What do you need to think about in particular? The first step, as with pretty much anything to do with corporate law, you should go and check the company's articles and any shareholders agreements that may be in place. Generally speaking, a company can carry out a share buyback unless its articles say that it can't. An exception is where you're trying to use the de minimis requirement, which we'll go on to talk about in a minute. If you're trying to do that particular type of buyback, it's the opposite position where you can only do it if your articles specifically allow you to. So check your articles to see what it says on buybacks or if it's silent on it. And then consider whether those constitutional documents contain any preemption rights that would need to be waived, or any additional consent requirements. So even where the company is the one buying back the shares rather than the shares being transferred to another shareholder, preemption rights can still kick in where the other shareholders need to waive their right to receive the shares. So assuming that your constitutional documents allow you to do it, you'll then need a share buyback contract. For private companies, it will be an off-market and much more straightforward buyback contract. They can be very simple. Key requirements are that it's in writing, that you identify the specific shareholder whose shares are being bought back, the number and class of shares, and the purchase price for the shares. It is possible to build in those requirements into a company's articles, but we'd always recommend that you have a standalone share buyback agreement as the most obvious tool to use. As I've said a few times, you need shareholder approval, so an ordinary resolution, again, unless your articles say that a higher threshold is required. Shares need to be fully paid up. You need to have sufficient distributable profits. And as mentioned earlier, that may mean that you need to carry out a capital reduction first in order to create those distributable profits by, for example, reducing your share premium account or other reserve. There are a couple of exceptions where certain types of buyback don't require this, but generally all buybacks require distributable profits. The purchase price, as we've said, paid in cash in full at time of the purchase, not deferred or contingent. And then in terms of what you do with the shares, once you've bought them back, generally shares that are bought back get cancelled and they stop existing. But if you have done the buyback out of distributable profits, it is possible to buy the shares back and hold them in treasury. You may like to do that where the shares are being bought back from an employee, for example, and you want to keep a pool available to other employees and reissue those to somebody else. But often companies want them to be cancelled. There is no minimum or maximum on the number of shares that can be bought back or the price payable for those shares, except that at the end of the buyback processes, or one or more, you need to have at least one non-redeemable share in issue. Obviously, companies limited by shares need to have at least one share in issue, but otherwise no minimum or maximum. Stamp duty, as we've said, may be payable if the consideration is £1,000 or more. And it's worth thinking now, as of 2022, whether the National Securities and Investment Act applies. So this applies to certain companies carrying out certain activities in certain sectors that the government cares about. So it's where the kind of sensitive sectors that affect the economy that the government might have a particular interest in. So things like artificial intelligence, security, cybersecurity, I suppose weapons, not the most common sectors that you can think of, but we can provide separate training on this Act if you think it is applicable to you, but it's where the Act applies because the sector that your business operates in is triggered by the Act. A buyback may require a mandatory notification to the Secretary of State for approval. And this is where the buyback will result in a remaining shareholder holding either over 25%, 50%, or at least 75% of the shares in the company. So if the buyback is going to trigger a change in threshold of ownership, where you get over those hurdles and you are in a relevant sector, then it may be you need to make a mandatory notification to the Secretary of State for permission to carry on with the buyback in advance. If you don't, and a mandatory notification was required, then the buyback will be void and an offence will be committed. So this often, this is completely company and sector specific. So it's something to be aware of when considering a buyback, but your lawyers will consider whether this is triggered in your particular circumstances. So in terms of what documents are required to carry out a buyback, this is all subject to any additional requirements as a result of how you're financing it. But generally speaking, every buyback for a private company is going to need an off-market buyback contract, an ordinary resolution, board minutes for the company approving the buyback, an SH03 form that's filed at Companies House, and an SH06 form if the shares are being cancelled. you don't tend to now need a stock transfer form to transfer the shares back to the company. It's the SHO3 form that's the kind of instrument of transfer. And if stamp duty is payable, it's that form that's sent to HMRC to be stamped. The key thing to be aware of is the timing of passing your ordinary resolution. So generally, there are two options. You either pass the ordinary resolution first and then sign your buyback agreement, or if you sign the buyback agreement first and then you're seeking shareholder consent, you need to make sure that the buyback agreement is conditional on the ordinary resolution being passed. So you can't kind of retrospectively approve it where the contract wasn't conditional. Post-completion requirements to be aware of, making your company's house filings. Your stamp duty, if there is any payable, needs to be paid first. You need to get the SHO3 form stamped by HMRC and then it is filed at company's house. An SHO6 if your shares were cancelled, and if you did need a special resolution because your articles required a higher threshold than an ordinary res, then that also needs to be filed. Then you can update your share registers, and you should keep a copy of the signed buyback agreement available for inspection for 10 years post buyback. And yeah, as we've said multiple times, generally the shares will be cancelled, but if it was a buyback out of distributable profits, then there's the option for holding the shares in treasury if the company would prefer to. So financing a buyback. There are generally 4 ways of doing this. As I've said a few times, the most common and simplest route is out of distributable profits. But it may be that you can do it out of a fresh issue of shares and the proceeds from that. Or there are 2 options out of capital. That generally the capital routes are more complicated and more onerous for the company, so they've fallen out of favour. And are not seen very often now, particularly because of well, it's not really that new, since 2008, the ability to carry out a capital reduction using the solvency statement route, so not going to court, has made creating the necessary distributable profits simpler, and then doing a buyback out of distributable profits, because that is now an easier way of doing it. Generally buybacks out of capital are less common, but it is still available, and I won't go through these in too much detail because you'll probably fall asleep, to be honest, but we can talk through each of these in more detail if they're relevant to you for a particular matter, but just to make you aware of the key requirements. So with a distributable profit route, it's, as I say, the most simplest route if you've got them. Otherwise, you may need to do capital reduction to create the distributable profits. The key thing to be aware of is that doing a buyback out of distributable profits is a distribution, and therefore it needs to be a lawful distribution. And you need to be able to show that the company has sufficient distributable profits by reference to relevant accounts. So relevant accounts is defined to mean your last annual accounts, if those show that at that time the company had distributable profits. If they don't, you can then look to create interim accounts, which could be your latest management accounts. If they then show distributable profits, that's sufficient, but you do want your board minutes referring to ideally both sets of accounts to show your analysis, and by reference to speaking to your accountants and getting them to opine on the position. If you're carrying out a capital reduction first, you need to complete that, including filing the relevant documents at Companies House. A capital reduction isn't completed until it's filed at Companies House. Then you need to create interim accounts that show the effect of that capital reduction, creating the necessary distributable profits, and table those at a board meeting to show you were then able to carry out your buyback. So it's that that sounds like there's multiple steps to it. It's primarily a timing issue. You need to make sure your capital reduction is fully completed and your accountants have created interim accounts for you showing the effect of that before you then rely on that to carry out your buyback. But obviously, if the company has distributable profits, it's quite a quick and straightforward means of buying back the shares. It may be that instead you wish to carry out a new issue of shares to fund the buyback. So it might be that your other shareholders didn't want to buy out the exiting shareholder directly, perhaps, I don't know, they've fallen out and they don't want to do it, or they don't want to incur the stamp duty on the buyback, but they're willing to fund it in a different way by subscribing for new shares in the company and then using the proceeds to fund the subsequent buyback. We can go through the detail if it's relevant to your company, but a key thing to be aware of is making sure that your registers, your share registers, are written up to date to show the effect of the new share issue before you carry out the buyback. And it's key that the documents evidence that the share issue was for the purpose of funding the buyback. So obviously board minutes saying that was the rationale is obviously helpful to evidence this. And it's sensible to make sure that the two steps follow each other in time. They're quite quick and close together. The bigger the gap between the two, the harder it is to show that the purpose of the new share issue was to fund the buyback. So that's the second option. Then, as I was saying, you can still do a buyback out of capital. Because this potentially can prejudice the interests of a creditor and go to the solvency of the company, it's the more onerous and slow process, which is a key reason why it's fallen out of favour. It has extra requirements, such as you need a director's statement specifying the amount of the permissible capital payment for the shares and confirming that the company can pay its debts both immediately and in the following 12-month period. That director statement needs to be supported by a report from the company's auditors to a similar effect. You then need two types of shareholder resolution. You need an ordinary resolution to approve the buyback contract, but you then need a special resolution to approve the payment out of capital. So if there's any concern with getting the 75% threshold passed, then this may not be an option. And then these subsequent requirements are relevant to creditors so that they're aware of what's happening, particularly where the company might be in distress, so that effectively you give them a window to block the buyback. So you need to publish a notice in the Gazette, which needs to be within 1 week after the special resolution was passed, and it needs to comply with certain requirements. You also need to publish a notice in a national newspaper or give specific written notice to each of your creditors. And again, within 1 week following the date of the shareholders' resolution being passed. You then have to deliver a copy of the director's statement and the auditor's report to Companies House, and that's within a day of the first of your public notices being made. And then in terms of actually carrying out the buyback and making the payment out of capital, you can't do it immediately. You have to give the creditors a period with which to object, basically. So it's between 5 weeks and 7 weeks. So no earlier than 5 weeks and no later than 7 weeks after the date the shareholders' resolution was passed, before you can carry it out. So it's much more onerous and lengthy. So I was just checking the chat. So the traditional capital route, as I say, isn't used that often. So the government came up with a little bit of a workaround to assist companies that want to do a buyback out of capital, where they're only intending to buy back a small number of shares, or only the nominal, the payment for those shares is minimal. So a private company can purchase shares out of capital where the aggregate purchase price for all shares that are bought back in any one financial year are the lower of £15,000 or the nominal value of 5% of the fully paid up share capital at the beginning of the financial year. So it puts a financial cap on the price that you can pay for the shares. And the way that cap works is that most often the relevant limit is the price can't exceed the nominal value of 5% of the shares in issue, which is often a very low amount, particularly where companies have their share capital at 0.001 nominal value. So it exists, it can be useful, but to be honest, it's not often relevant, because typically, in our experience, where you are buying back shares, it's to pay fair market value to an exiting shareholder. Quite often it may not be relevant. But if it is relevant to you in your particular circumstances, then it's only available where your articles specifically allow it. So you need a particular provision in your articles saying that you can do this. It's worth amending your articles to include it if it doesn't already, just so that you have the ability. It's not automatically under the model articles, so it's worth thinking about. But as I say, in reality, it's not that commonly used. So say you want to do a buyback and you have attempted to carry it out. What are the most common scenarios where you've made a mistake and therefore the buyback is void? Probably no surprise. The key one is where you tried to fund it out of distributable profits and you didn't have sufficient distributable profits. Whether maybe because your capital reduction wasn't completed properly first, or because you thought you had them and you just didn't. In that scenario, the buyback will be void, but you've also made an unlawful distribution to the exiting shareholder, where that exiting shareholder is liable to repay the amount they received to the company. So not a great position to be in. Other common mistakes are around the purchase price that was paid. So if you've left it outstanding as a loan, or you tried to fund it out of non-cash consideration, so some kind of in specie payment, or you paid it after completion, or you said it was payable only in certain circumstances or subject to an earn-out of some description or in instalments, then all of that would make the payment void. As we've said a few times, it needs to be paid in full, in cash on completion. So where your buyback is void, an offence is committed by both the company and every officer at the time that was in default. So not great, and particularly investors coming in, it's quite a big red flag. Or if you're trying to sell the company and people are doing due diligence on your share history, they can flag that a buyback wasn't valid, and it raises the question over whether those shares are still in existence and if that exiting shareholder needs to participate in the sale or funding round. It's not all doom and gloom if these things do happen, because there are potentially two rectification routes that you can go down. So you can't ratify something that was illegal, but you might be able to take steps to rectify what you attempted to do in the first place. The two key ways of doing this is either carrying out the buyback again or cancelling the shares that were purported to be bought back via a capital reduction. Which one is going to be most appropriate will depend on whether the exiting shareholder is still traceable and whether they're willing to cooperate and potentially carry it out again, and also the time that's passed since the buyback was first attempted and when you're trying to rectify it. So it may be that if it's only just been attempted and you spotted that there were mistakes, you can sort of rectify it by doing it again, basically. Or if it was quite a lot of time has passed, or it was a contentious situation where that exiting shareholder isn't going to play ball, then the reduction of capital and cancelling the shares route is probably the most appropriate. So if you're carrying out reduction of capital to cancel those shares, you can disregard the selling shareholder as a member, so they don't need to participate in or receive notice of any shareholder resolutions to cancel the shares, which is useful. You then carry out a capital reduction via the solvency statement route. You don't have to go to court, and cancel the buyback shares at the end of it. And even if you have subsequently, say you try to buy back B ordinary shares of £1, and you have then subdivided your B ordinary shares into 10p shares, you can still say in your documents that what you're cancelling is the B ordinary shares of £1. You don't have to take into account subsequent reorganisations of the share capital. But obviously you need to be able to make the solvency statement by the directors. We'd then also recommend that you enter into deeds of release, under which the company releases the selling shareholder from any liability to repay the original consideration, because technically the original distribution was unlawful, so they should be liable to repay it. So you enter into a deed of release saying that they don't need to repay it, and releasing the directors that acted at the time from any liability connected with the void buyback, because they would have technically committed an offence by approving it. And then ratify your previous accounting entries. So you can sometimes tidy this all up and still cancel the shares, provided you can comply with the reduction of capital solvency statement procedure. The alternative is to carry out a corrective buyback and effectively do it again. You need to reinstate in this route the selling shareholder back on the register of members retrospectively. And you then account for the money that was originally paid to them as an outstanding debt owed by the selling shareholder back to the company, again, because of the unlawful distribution point. Sign a new buyback agreement where the consideration for the shares this time is nominal value or £1, because you've already paid the original consideration in the first attempt. And your board minutes and written resolution should refer to the background and why you're carrying out again, and sort of explaining the narrative. And then again, enter into deeds of release to release the selling shareholder from owing money back to the company, and where the selling shareholder should enter into a deed of release to waive any right to dividends that they should have been or may have been entitled to participate in from the date that the first buyback was attempted. So releases in both directions, and again, ratify your accounting entries. So both routes are a little bit cumbersome and have a few steps to them. And the route that's most appropriate will depend really on your selling shareholder and whether they are willing to help you out. But there are ways around it if the original buyback was void or had issues. But obviously, best to get legal advice in the first place and to avoid those issues. But a buyback, if you have sufficient distributable profits and it's a useful tool to get the shares back. It can allow, if the shares are cancelled, all the remaining shareholders to get an uplift, their percentage shareholding is increased, and it's a neat and tidy way of cancelling certain shares. So that was kind of a whistle-stop tour. I appreciate it was a lot of information thrown at you. I'm very happy to take any questions if anybody's got any. radio silence. So
That was very helpful. I just wanted to pick up on one of the rectification actions you were talking about in redoing the buyback, because you said that if you were going to redo the buyback contracts, the consideration could be nominal value, in which case you're not paying any stamp duty to HMRC, right?
yeah, correct. You wouldn't on the second. You should have paid it on the first attempt. So if it was payable on the first attempt and it hasn't been paid, it does need to be retrospectively paid, and you may be liable to a fine on the basis that it should have been paid the first time and maybe is now being paid late. But if you paid it at the time but there was a problem with the buyback, so you do it again and the purchase price the second time is minimal, then yes, you wouldn't incur stamp duty twice. Okay. Happy to be contacted later on if anyone's got any other questions. Otherwise, thank you very much.
Thank you so much, Georgia. Oh, sorry about that. Just to let everyone know, we will be circulating the recording and the slides, and I will also be circulating Georgia's contact information if you had any further questions that you wanted to email her about. Thank you for joining.